be seated. We will hear argument in case number 240132, Privilege Underwriters against Mankoff.
May it please the court, Mr. DeBose will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. This is the case about whether the word windstorm in a deductible provision of a homeowner's policy includes the tornado that damaged the Mankoff's home. I'd like to cover two topics today. The first, briefly, wind. Second topic, in a little more depth, rain. Those are the two features that the Mankoffs try to use to distinguish this tornado event from a windstorm. So first, on wind. If the court looks at all of the dictionary definitions offered by any party, the common feature of all of those definitions of wind is a strong or a violent wind. It is not limited, the dictionary definitions are not limited by the wind direction. They don't distinguish, for instance, between a straight-lined wind or a circular wind. Now, the Mankoffs have argued that because a tornado has circular wind, it's different, but that doesn't fit within the ordinary meaning of the word windstorm. In this case, because it's a homeowner's policy, because the term windstorm is undefined, the ordinary meaning of windstorm should control. There are some meteorological sources that the Mankoffs have cited that say that sometimes they're classified differently. Their meteorological expert, however, in his affidavit, said that the word windstorm has never been used as a true meteorological term, but is more of a layman's term. And that was at page.
So I have a question about that. You
Yes.
know, whenever we're looking at dictionary, or wherever we look to figure out
Yes.
the ordinary meaning of something, what should we use? Should, explore that with me.
Sure. So there's first line, as this court has said, is you look to the dictionary definition.
Yeah, but
which also
what
look to
does that mean?
context. Well, you look and see what definitions are in the dictionary, and then you look at the context to see which, if there are more than one,
Well,
which.
but in this situation where you actually have someone who's an expert in the field that may be defining it a little bit differently.
Right, but the policy is geared at homeowners, not at meteorologists.
Yeah, I know. You notice I intentionally did not use that word.
Well, so think about it in an oil and gas case. Should we look at Webster's or should we look at the Manual of Oil and Gas Terms to know whether, and then sort of, can you help us generalize that?
Yeah, sure. So if you've got an oil and gas case where the two parties are in the industry, you typically look at the industry meaning. If you have an oil and gas case where someone is, one of the parties who signed a contract is not in the oil and gas industry, then you would probably look at the ordinary meaning.
So does that mean we'd look at Google? Would we look at AI?
I am suspicious of the internet to a certain degree, but dictionaries are the tool that we have historically used to look at what ordinary English usage is. And so that's why I think that's the place where we should start.
What about corpus linguistics? Like, how is this term being used in newspapers and things? And I think there was one source that was cited about like how that had some examples of how windstorm and tornado were used, and you say, oh no, we can't look at that.
Yeah, there's some academic discussion about using that. That's never been cited in this court's jurisprudence as a source that I know of. But the problem with usage is if you look, for instance, at the usage examples, none of the usages of windstorm would exclude a tornado. The fact that there are some instances of usage that refer to a derecho as a windstorm doesn't mean that a tornado is not a windstorm. Both are specific types of meteorological events that fall within that umbrella term that's primarily used by lay people.
That was Justice Miskell's point, I guess, that
Right.
it's a subtype of the tornado is a subtype of a windstorm.
Right. I think the primary argument at this point in the briefing is rain, and so I want to next focus on rain. Some of the dictionary definitions include the phrase with little or no rain after a violent wind, storm with violent wind. They say something like with little or no rain. We've cited at least one definition that does not. So I'm going to first talk about the facts and then about the definition. I think under any definition, any dictionary definition of windstorm, this event had little or no rain because the only evidence, summary judgment evidence in the record was a meteorologist's opinion that there was likely 2 minutes of rain after the tornado. So first of all, it's not a quality of the tornado. And secondly, it's 2 minutes of rain. And in Texas, where it can rain for days, by just about anyone's definition, 2 minutes of rain is little rain. And so it falls within that definition, little or no rain. For that reason, I think this case is easy. But there is a more difficult question, and that is, what happens if you have a tornado with a lot of rain? Does it meet the definition? And to the extent that the court writes an opinion that defines what a windstorm is or follows definitions of what a windstorm is, I would like to recommend Justice Miskell's approach and explain why it's consistent with some other cases that have been cited in the brief. So Justice Miskell's dissent looked at a number of different definitions of windstorm and looked at the common thread of those definitions. And among all the definitions, some said little or no rain, some didn't, but under all of them, the common characteristic was a strong or violent wind. And that's the key characteristic of a windstorm. And that was that approach, what Miskell called the common thread approach, is what this court used in City of Fort Worth versus Pridgen in defining the word report. It looked at the common thread in the definitions of the word report. This is a very similar approach to what the Eastland Court said in 1946 when it defined windstorm in the Fireman's Insurance versus Weatherman case, which for a long time has been the leading case in Texas about windstorm. In that case, there was a jury charge definition of windstorm that did not include the phrase little or no rain, and there was a complaint about that. And the court said, if you look at all of the cases around the United States that have previously looked at the meaning of the word windstorm, some of them mention that, some of them don't, but the key feature of all the opinions is violent wind, and we don't think that precipitation is necessarily part of the definition. There's also
the Mankoffs argue that because this isn't a coverage dispute, but instead involves the scope of an undefined exclusion from coverage, the definition ought to be construed in their favor, or the policy. So it sounds at least that their approach would be defining tornado as not a windstorm in this case doesn't preclude someone from arguing that it is a windstorm if they're trying to invoke coverage. And what's your response to that?
Right. And so it is a deductible provision, which Texas has treated as an exclusionary provision. And the rule for those is if the language is ambiguous, it's automatically construed in favor of the insured and not the insurer. So the threshold question, though, is whether there's an ambiguity. And if there's not an ambiguity in the first place, then you don't get to that phase. And so if you look at all of these, and this is one of the things the insurer amicus brief dealt with, there are all these opinions around the country, and almost none of them, if any, have said that the word windstorm is ambiguous. So if there is an ordinary meaning, and that's what the Fireman's Insurance case, which is not about exclusion, I mean, that's a difference with that case, but it still says this is what we think the word windstorm means, this is the ordinary meaning, and it's consistent with that meaning not to mention precipitation in the definition.
And if there is an ordinary meaning, it should be the same meaning, whether it's to invoke coverage or to apply a deductible.
Right. If there's an ordinary meaning, that's right. has to be first a determination that it's ambiguous before that rule of construction applies against us. Let me just point out one other thing that I think the Mankoffs mentioned this in their brief, and it's an interesting point. The word windstorm is a compound noun, and it combines wind and storm. And there are a number of compound terms that combine with storm. So you've got rainstorm, you've got snowstorm, you've got thunderstorm, you've got hailstorm. And what is different about each of those words is the first word, which qualifies storm. And so the primary characteristic, or a characteristic of all of these events, is the first word. It's wind, it's rain, it's snow, it's hail. And none of these are meteorological terms. They're all broad lay terms that there are specific meteorological events that fall within under them. For instance, a rainstorm includes thunderstorms, it includes tropical cyclones. A snowstorm includes blizzards, and includes snow squalls. Windstorm is a similar common term that's used as an umbrella term, not as a precise meteorological term, to refer to a number of different events. And that's how it should be treated in this case. If there are no questions, I'll yield the rest of my opening time to the court.
Any further questions? Thank you, Mr. DeBose. Mr. Pitts for the respondent.
May it please the court, Mr. Pitts will present argument for the respondent.
Mr. Chief Justice, may it please the court. I'll focus my presentation today on dictionaries, context, and common usage to the ordinary person. And I'd like to begin with a few litmus tests. First, if the National Weather Service were to warn of a windstorm when it was a tornado approaching a neighborhood, it is easy to imagine the public feeling misinformed. Second, if you had dinner with a friend and said that a windstorm damaged your home, it's hard to imagine that person thinking of a tornado. These examples go to my central point today. The problem with Pure's argument is that the word windstorm is commonly used, undefined, in a narrow sense, to refer to a categorically different type of a weather event from tornadoes.
So lots of Texans along the coast purchase windstorm coverage. Would it come as a surprise to them that if during a hurricane event there was a tornado that took their house out, that the coverage wouldn't apply?
Your Honor, that's an excellent point. And I think there's two senses to the word windstorm. There's a broad sense and there's a narrow sense. And it's interesting to look at the case law and the dictionaries to see where those began. And the amicus brief in support of Pure points this out, but in 1911, the Iowa Supreme Court issued a decision, it's the Jordan case in the briefing, where they noted the Webster's Dictionary at the time, which was a storm with strong winds, little or no precipitation, and just chose a different definition. They went a different route that deviated from the dictionary usage that was in effect at that time. And so there's been a diverge from the case law and the dictionaries and common uses from that time. So in the coverage context and insurance contracts, that's right, it has a broad sense. It has covered all sorts of wind events. Pure actually amended its policy in 2023 to define windstorm as a storm with or without winds, so basically any storm ever. But there's two senses, and the dictionary is where you go to get to the narrow sense. So if you would look at tab A of my oral argument exhibits.
So right, you see the problem that if we conclude that a narrow definition applies for windstorm here, that would then be a tool to deny coverage in cases where there is windstorm coverage if the windstorm was, had a tornado as part of it.
Your Honor, I hear the point, but I disagree because the insured always gets the benefit of the interpretation in its favor when a term is reasonably susceptible to two interpretations. And windstorm is reasonably susceptible to two interpretations. One is the broad sense that's developed in the case law in which a regular Texan will not have read, and the other one is the dictionaries. So if you look at tab A, and this helps make the point, but if you look at tab A or argument exhibits, we have a diagram of the type of supercell thunderstorm that creates a tornado. You'll see it has precipitation. It's this massive structure that reaches into the atmosphere. Precipitation is an important part of what helps the tornado form. And if this sort of storm hit an insured's house, in many cases they'd be hit by heavy precipitation, and then afterwards a tornado would tear through the house. And if they had this deductible, windstorm or hail, and they experienced that heavy precipitation, tornado right after, which is the paradigmatic storm, and this is from the National Oceanic Atmospheric Administration's Severe Storms Laboratory. If they got hit by that paradigmatic storm and they opened the dictionary, they would think that that was not included in the deductible because the storm that they experienced had much more than little or no precipitation. And that is the narrow sense of the term, Your Honor. There's two senses, a broad sense and a narrow sense. In the coverage context, the broad sense is always applied. And you see that in the case law cited, the amicus brief. They've adopted this. There's a few common law tests, but it always goes to the strength of the wind. But they ignore the dictionary definition, and the ordinary person will first open the dictionary definition.
Which dictionary definition can you point us to that would exclude tornadoes?
Your Honor, I would argue Merriam-Webster, the American Heritage Dictionary, and the New Oxford American Dictionary, because they include the with little or no precipitation element. And that's the key element that takes a tornado out, because the type of storm that generates a tornado has this heavy precipitation. And it's a categorically different type of storm than with little or no rain, which would be a strong cold front with gusty winds, which you get a lot in Texas. Dust storms or sandstorms are a classic example. I think they're called haboobs in West Texas. I think they're an Arabic word. But there's
funnel clouds. Dust storms are really they create a lot of funnel clouds. Are those tornadoes?
So a tornado, Your Honor, extends from a cumulonimbus cloud, and the funnel of the tornado is actually made of precipitation. It's made of water droplets.
Got it.
And there can be other debris, of course, in the funnel of a tornado. But the storm that creates the tornado has heavy precipitation. And that's what these dictionaries are excluding.
If windstorm excludes precipitation events, then the Texas Windstorm Insurance Association is pretty poorly named, right? Because it's pretty much exists for hurricanes and tropical storms.
Well, Your Honor, I would agree that in the insurance context, it's traditionally had a broad meaning. But that is divergent from the dictionary meaning, and it's divergent from what people hear in the news. Weather forecasters and meteorologists who tell Texans what weather is coming, they never use the word wind or windstorm to refer to a tornado. They refer to a tornado as a tornado, and high wind events as high wind events. And if the narrow sense is never credited, and this word starts appearing in exclusions all the time, and for example, there's exclusion in the record from Pure that excludes windstorms. It's an endorsement that would exclude windstorms. So a Texan might be surprised on the other side if insurance policies in Texas start including exclusions for the word windstorm. Because the word has two reasonable...
Well, it changes the deductible for windstorms.
Right, correct. In this case, Your Honor.
It has coverage, but it's a 2% deductible.
Correct, Your Honor. But you could imagine in a different case where the insurer puts this exclusion in the policy in the back, and they use the term windstorm, and then this comes up again, and the question is, well, does that just get rid of almost the tornado is the most devastating event that can happen to a home, so would that cover it or not? And so there's two senses, right? I think in the coverage context, it's always had this definition, but there's only one case, actually, that I could find that can interpret it in the exclusion context, and that's the Bliss Mine Road case in the Rhode Island Supreme Court, and they found it ambiguous because they applied the dictionary definition when this term was used in almost an identical deductible to the one here. In that case, the storm was a big nor'easter that went up to the northeast, but they found the term ambiguous on the dictionary definition.
So are you suggesting that we would have a uniform rule that it would be found to be ambiguous in one context and unambiguous in the other?
No.
That would be strange.
No, Your Honor. I just think the term's reasonably susceptible to two interpretations. I agree it's strange for that to be the case, but it's because the case law diverged a long time ago in 1911, and the dictionaries and skilled lexicographers that make them have kept the word uniformly defined as a storm with high wind with little or no precipitation. And if you look at the dictionaries they cite to the contrary, it's British English. And the test here is what the ordinary meaning in Texas, and the British English dictionary shouldn't govern. So I think it would just be susceptible to two reasonable interpretations. And I do think it's important to consider the meteorology evidence that's in the record. Meteorologists classify these events is totally different. They don't think
Are you saying it should be susceptible to two different meanings even in the coverage context?
Yes, Your Honor. And in that case, if it is, then nothing changes for coverage because there's a broad sense that the insured would get if it's,
Sure.
and then if the insured put it in exclusion, they would get the benefit of the interpretation in their favor. I do want to note that the Texas legislature also suggests that this word has distinct sense. If you turn to tab B or argument exhibits, this is one of the many statutes included in our or argument exhibits. But it's just an example of the Texas legislature allowing co-insurance against the hazards of tornado, windstorm, or hail, just putting them in there as separate hazards. So I think that's some indicia that the words have distinct meaning. And if you look at the insurance policy at issue itself, I think it also supports that there's a narrow sense of the word, because this policy covered all risks unless a peril was specifically excluded. That's in section 2A of the policy. And then if you turn to tab C or argument exhibits, you'll see that windstorm is a special deductible from an all risk deductible, or an all other perils deductible, excuse me. And the fact that it's used, it's a specific narrow deductible carving out a specific thing. It's not used as a broad catch-all term in the policy itself. Justice Bland, I think you asked some questions about the standard in Texas about how to read exclusions. This case law goes back a long way, and all the way to the 1950s, I think. I think it was actually called well settled then. But it's true that it's interpreted in the insured's favor when it's exclusion generally, but there's also some strict construction canons in all doubt resolved in favor of the insured. You can find that in the Continental Casualty versus Warren case and some others that follow it, including the RSUI indemnity case written by Justice Boyd in 2015.
What is your response to the point made by your friend on the other side that in this instance there were just 2 minutes of rain after the tornado, so the dictionary definitions that would require that precipitation might not really be relevant here at least?
So I think there's two things that I'll say there. First, the declaration also says that this tornado was part of a parent thunderstorm and a tornadic thunderstorm that had precipitation, namely hail. It doesn't mention that rain, but that's also a part of what's going on there. There's not evidence in the record about how much precipitation was associated with the parent storm. But then the 2 minutes of rain that likely followed it, I mean, I think that's enough to bring it out of the little or no category in the dictionary definition.
What does little mean, do you think?
Your Honor, I can't measure it with a ruler. I think 2 minutes is probably more than little or no, which usually denotes a very small amount. And it could be a jury issue about whether a storm had sufficient precipitation in it to amount to not a windstorm.
But it wouldn't be a jury issue here, right? Because the tie goes to the insured.
Correct, Your Honor. Our argument is that categorically the definition used in the dictionaries with little or no precipitation excludes tornadoes, just because of how the storms form in the part that there's part of supercell thunderstorms. But I mean, conceivably, if the court just adopted the dictionary definition, we put in evidence that there is some precipitation. It's pure burden on an exclusion to offer evidence that there's little or no precipitation. And we had cross motions for summary judgment. There's no evidence motion, and there's nothing close to conclusive proof about the amount of precipitation in this storm. But our primary argument is that we categorically win based on the dictionary definition. A few final points I'd like to make, Your Honors. First, there's some other courts that have found it ambiguous. Some of those are referenced in the amicus brief. Those are some cases from New York. And then there's also a case referenced in the amicus brief, Morris versus Allstate Insurance, where a few California district courts also just applied the dictionary in a similar way using the little or no precipitation element. The takeaway today should be that the windstorm has a narrow sense and a broad sense. The dictionary with the little or no precipitation element signifies the narrow sense, and that's why Pure eliminated it from its 2023 policy. So its policy no longer has that. The broad sense is reflected by the case law flowing from the 1911 Iowa case. And it's not unreasonable for the insureds, after reading the dictionary, and we haven't talked about the encyclopedia, but the encyclopedia also says that tornadoes are classified separately from tornadoes, and then it goes through a whole discussion of what sort of events would be windstorms, and none of which are like tornadoes. But a reasonable insured in Texas could open the dictionary, open the encyclopedia, and think that the storm that damages the tornado is categorically not a windstorm because the storm that creates them has precipitation. Insurers can control their risk by writing their policies more clearly. Pure could have defined the term windstorm in this policy, we wouldn't have this dispute. But they didn't. They put it in an exclusionary context with no definition whatsoever. And insureds need clarity in what type of insurance they brought, in plain English and not code.
Justice Lerman asked about this before. Why do encyclopedias matter here? We've had dinner parties. We've talked about weather, what the weatherman says. So why do encyclopedias matter here?
Sure, Your Honor. So the encyclopedia is sort of a Cliff Notes version of what meteorology says about the term. When you go to the encyclopedia on the internet, if you could type in windstorm, it says windstorm and then in parentheses meteorology. And then the excerpt was written by a professor at Colorado State of atmospheric science and then reviewed by sort of editorial board.
So it seems like your argument is if you can show ambiguity, then representing the insured, you win, and then you can expand the universe of sources that we should consult. Encyclopedias, what did the weatherman say? What does this or that dictionary say? And then if it could just mean derecho, then it means just derecho. So have we ever looked to encyclopedias before? Or
There are a couple cases cited in the briefing.
Chamberlain with the weather or whatever?
There are a few cases cited in the briefing where the court has used encyclopedias for things such as, I can't remember exactly what, but they're sort of background, they're used in the background sense. But I think under this court's precedent, under URI Inc. versus Cleburne County and then Endeavor Resources and other cases, the court can look to objective sources that inform on the meaning of a word. And here are the words windstorm, of course. But as long as they're objective, and there's nothing in this record that goes to subjective intent or in adding or altering the terms. We're just trying to figure out what the word windstorm means. And it's important because in this context, Pure is asking the court to say what the only reasonable definition of windstorm means. Because if the insured wins in the exclusionary context, that's the only reasonable definition of the term ever. So it matters what meteorology says, because if the court were to adopt a term that was contrary to meteorology and contrary to what people hear in their everyday lives, that would create a disconnect from the reality that people experience.
So if we write this opinion in that way, it seems like insurance companies need to buy a thesaurus. And basically, instead of saying windstorm, they need to see derecho, dust devil, and nor'easter, and all of these other things. And that's what they should do if it's exclusion, but they don't need to do it on the coverage side.
It depends on what risks they want to cover or exclude, Your Honor. But that's right. And in many policies, they do. They do list those out. And in fact, in Pure's amended policy, their exclusion endorsement defines windstorm and lists out all the things.
Well, if you were counseling them, wouldn't you tell them to do the same thing based on the Court of Appeals opinion?
Well, I think they did that before the Court of Appeals decision, but yes, Your Honor. The best practice for ensuring the exclusionary context is always to define the term because the insurer is going to win in a duel. That's
But then do they also have to define what little means? So they say tornado, was this a little precipitation or a lot? Little means of a small or insignificant degree. What does insignificant mean? Turtles all the way down.
Yeah, of course, they could define it. There's all sorts of things they could do to deal with that. And in fact, how Pure did deal with it is they just took out the element altogether because the element signifies this narrow meaning where sort of like strong cold wind winds, blue northerns, dust storms, those sorts of things that don't have precipitation, which is the traditional dictionary definition. And they cut off with little or no precipitation given the kind of storms that create tornadoes.
Any further questions? Thank you, Mr. Pitts.
Thank you.
Mr. DeBose, you have 5 minutes.
Three points. First, under any dictionary definition offered by the parties or the amici, the tornado here was a windstorm. Even if you look at narrow sense, broad sense. The narrowest sense that the Mankoffs have offered is little or no rain, and we have a summary judgment record that says likely 2 minutes of rain after the storm. Now, is that sufficient summary judgment evidence? In City of Keller, this court explained that the scope of review for a summary judgment record is the reviewing court must examine the entire record in the light most favorable to the non-movement. Of course, here we had competing motions for summary judgment, but in terms of seeking our motion for summary judgment, reviewing courts do not disregard the evidence supporting the motion, because otherwise traditional motions for summary judgment would never be granted.
Would the analysis be any different if the language were loss caused directly or indirectly by wind or hail? Like, is the storm compound doing anything?
I'm not sure.
It's a little odd, like windstorm and hail. You could have said hailstorm, but it just says hail. You could have said just wind instead of windstorm.
Right.
I mean,
what makes a storm is essentially an atmospheric disturbance. If you look at all the definitions of storm, that's the common quality. So is all wind an atmospheric disturbance?
Is all wind that's strong enough to damage somebody's house a windstorm?
Yeah, I think so, but I'm not entirely certain about that.
What is your response to his argument that if over the, the emergency system, people are warned, or I don't know if warned's the right word, but, a windstorm's coming, and then to their surprise, it's a tornado coming. What's your response to that?
I think if you say windstorm, or if you say wind, people are going to expect a strong wind and to be concerned about the wind, especially if it's a warning like that. I'm not sure if they issue warnings specifically for or generally for windstorms, but yeah, I think that, or you get a hurricane warning, for instance. Right. So this is my second point, and it goes to that, and that is, this is a homeowner's policy, and you're trying to use very general language, and you could, like Justice Sullivan mentioned, list all the different events. That's problematic, because one, if you do that for every provision of the policy, it makes it a lot longer and a lot harder to understand, and people are less likely to read it. But second, you run a risk as an insurer. If you list some types of windstorms but not others, there's going to be a risk that someone's going to argue, well, you didn't list this specific type of windstorm, therefore it doesn't apply. And so much better to just simply use the word windstorm.
Or just say wind.
Or wind.
I mean, it's all wind, right?
Right. I think you could do either one. Now, counsel mentioned there was a subsequent policy exclusion that excluded windstorms, and it defined windstorms essentially to mean all storms. That, I think, changes the ordinary meaning. And so you have to define it in that circumstance where you're departing from ordinary meaning. But unless you're departing from ordinary meaning, it makes sense in a homeowner's insurance policy to use general language. And then my final point's on statutory redundancy. There are some insurance code provisions that use windstorm and tornado in the same breath. But they also are part of, in many cases, a much longer list, such as 252.003 of the insurance code lists tornadoes, windstorms, flood, rain, weather, or climactic conditions. You've got general terms, you've got specific terms, they overlap. I don't think the fact that there's some overlap means that there's an intent to exclude one from the other, but even if there were, that's applying a canon of construction to an insurance code provision to try to find that the usage of a word in an insurance policy isn't ambiguous. And that's an improper use of a canon of construction. You can't use it to create an ambiguity, certainly not by looking at a statute in order to define an insurance policy. We ask that the court reverse. Thank you.
Any further questions? Thank you to all counsel. That concludes the argument set for today, and the marshal will adjourn the court.
Ayes. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.